Advocate Kasiboto, you have the platform, Advocate.
Thank you, Chairperson. Thank you, Chairperson. Good afternoon again, Mr. Klaus.
Good afternoon, Mr. Kasiboto. Committee.
So before we went on the lunch adjournment, I'd made the suggestion that you did not pay due regard to your functions by not verifying the people that were charged. I want to take that proposal further. I want to also suggest that it also means, now when I say it, the fact that Ms. Mkondo was charged, it also means the subcommittee on physical removals also did not perform their functions properly. Can you accept that as a proposal?
The committee, the subcommittee of the Rules Committee performed its functions properly. So I don't accept that proposal.
How can it have properly applied its mind to the case of Ms. Mkondo if we now accept she should not have been charged?
Sorry, I must object at this stage, Madam Chair.
Yes, Advocate Golden.
Thank you, Chair. I feel compelled to object at this stage. The supposition that Mr. Kasiboto put to Mr. Counsel, in other words, he put to him that now that we accept that the charges must be withdrawn, Mr. Counsel did not accept that at all, nor did he make the concession that those charges must be withdrawn. The only charges that can be withdrawn, and if it is withdrawn, procedurally, we now know it's already on the record, can only be done by this committee. So I must object to that. That is a flawed and factually incorrect proposition that is put to the witness. It's not fair to him.
Advocate Kasiboto.
Thank you, Chairperson. The question I was asking is this. I'm not going to respond to the objection. Let's move on. The proposal then I made to you is that...
But can we then agree that the committee will make the determination on that?
I'm happy with that, Chairperson.
Chair,
Yes,
sorry.
as the correct structure.
Sorry, Chair, through you. May I also then ask that Mr. Kasiboto is also duly warned for not putting incorrect propositions to the witness, and this is to be fair to the witness.
Thank you, Advocate Golden. Advocate Kasiboto, the committee is the one that will deal with the withdrawal or not withdrawal of the charges as the correct structure that we indicated when we started here. We are investigating and we will report to Parliament as correctly said. So please refrain from doing that and withdraw such propositions as indicated so that we don't get hiccups as we deal with your cross-examination.
Thank you, Chairperson. I accept your ruling. Just to assist in that respect, all I simply said is a proposition I put to Mr. Klaso earlier on is that if she wasn't there, then she shouldn't be charged. That's all I was dealing with. That is not a factual inaccuracy. It was his own evidence, but I'm happy to accept your ruling and I'll move on. And I promise, as I haven't, not to put in factually incorrect suppositions. Mr. Klaso, the proposition I then made to you is that the subcommittee on physical removals clearly then did not properly apply its mind, at least to the, I'll show you in other instances where there was incorrect application of the mind and that your evidence was false. But I'm now just dealing with Ms. Mkondo, and I'm saying to you, if your evidence is that the subcommittee ought to have applied its mind to the facts, and we accept, or at least I put it to you, that they ought to, then had they properly applied their minds, then at some point at that subcommittee, it should have been noted that Ms. Mkondo is not guilty of at least charge 3. And you're saying you do not accept that. You say the subcommittee did its job. Now my question is this: how can they have properly done their job if I am correct that Ms. Mkondo was not available at the chamber?
Chairperson, I think I should make this point, which I had made before. The subcommittee does not charge people. The House does not charge people. The Rules Committee does not charge people and did not charge people. So my submission, Chair, and the committee, and my response to Mr. Kasiboto is that the committee did apply itself properly on the issue. May very well be that there was a misidentification of the person, which was a genuine omission, even on my part. So, but the committee did apply itself. And it, of course, it will be for this committee to consider all those factors when it gets to that point.
The further proposal I'm putting to you is that in the same vein that you, the subcommittee on physical removals, had not applied their minds, the same can be said about the Rules Committee, because it too did not raise the fact that Ms. Mkondo was not at chambers. Is that fair to say?
Chair, as I indicated, the Rules Committee, the subcommittee applied themselves properly on the issue.
And in the same way, I'm accusing you, the subcommittee on the physical removal, the committee on the Rules Committee, in the same way I accuse them of not properly applying their minds. This committee did not apply its mind before it made the recommendations to charge Ms. Mkondo. Do you have a comment?
The committee will answer for itself, Chairperson. That's not for me to respond.
You're saying that's for you to respond.
It's not for me to respond to that.
Why is it for you to respond on the Rules Committee?
Because I support the Rules Committee and I advise the Rules Committee and the subcommittee. I don't advise this committee. So it is for this committee to deal with that matter.
Why is it for you to speak on behalf of the physical removal and the Rules Committee?
If you may, Chairperson, through you, if Mr. Kasiboto can repeat the question.
I'm saying you are not prepared to speak on behalf of this committee. You're saying it will speak for itself. Yet you are prepared to speak on the other subcommittees. And I'm saying why.
Chairperson, it's simple. And I'm not sure why it should be an issue. I'm speaking here on for what happened in the House on the days in question. I mean, that should have been the query. Why am I speaking for the House? And I'm speaking here for this in the subcommittee, what happened in the subcommittee and the Rules Committee, because I've indicated I advise those committees.
Very well. But you can accept that in as much as you advise them, they remain human beings that man those subcommittees, not so?
Yes, I accept that, which is obvious. Yeah.
And they've got their own minds, don't they?
No, they do have their own minds.
And you had suggested earlier on, you will not purport to speak on behalf of anyone, including the speaker. Did you not?
No, I did. Chairperson, I think I need to clarify this. It is my view that that committee applied itself. It is my view that the Rules Committee applied itself on the matter. And that's really my view.
Very well. Let's deal with Rule 73 of the Rules of the National Assembly. You can accept as a starting point that the Speaker is bound by all the rules of the National Assembly, not so?
Yes, the Speaker, like any other member, is bound by the rules of the National Assembly.
Including when she makes rulings, not so?
The Speaker follows the rules of the National Assembly to the best of her ability, as far as I'm aware.
Yes. And she's not allowed to deviate from the rules, not so?
The person I've said to the best of her ability. That's really what I can say. That members are expected to comply with the rules. Speaker is a member of the House, and so are members of this committee and any other member.
You see, this is the thing with the elongated answers that are not direct to a very basic question. I end up not understanding what the answer is. A yes or no could have sufficed here. The Speaker is not allowed to deviate from the rules.
Chairperson, as we have dealt with this before, Mr. Kasiboto is entitled to ask me questions, and he may not tell me how to answer. So I've responded in the manner I deem appropriate.
I can appreciate that, Mr. Glasso. I'm just trying to get you to assist me. So not for your benefit, for my benefit, if I can ask kindly. And perhaps for the benefit of the other committee members who might not be certain what the answer is. So I want to ask for your indulgence that to the extent you can answer the question with a yes or a no, can I please, and I'm asking for your indulgence, that you grant me that indulgence just so I know what the answer is.
Chairperson, to the extent that I can. To the extent.
That's fair. That's fair enough. So I'm going to ask the question again. The Speaker is not allowed to deviate from the rules. She's bound by them.
Chairperson, members are not allowed to deviate from the rules, including the Speaker. Yes.
That's good enough for me. Now let's deal with Rule 73. It says if a member refuses to leave the chamber when ordered to do so by the presiding officer in terms of Rule 70 or 71, the presiding officer, i.e. the Speaker, must, and I place emphasis on the word must, instruct the Sergeant at Arms to remove the member from the chamber and the precincts of Parliament forthwith. The proposition is this. The word must is preemptive. Would you accept that?
Madam Chair, sorry. May I object to this
Yes,
line of
Advocate. Yes, Advocate Golden.
Thank you, Madam Chair. Madam Chair, I think that I need to raise this because this line of questioning is not appropriate for this hearing. These are legal issues and legal interpretation of the rules that Mr. Kasiboto is now engaging the witness on. Mr. Counsel is here to give evidence as to what transpired in the House on the 9th and the 10th of June 2022, because he was there personally, he was physically present and observed the disorder and chaos in the House. So he was here to take us through that. That is the purpose of his evidence. Given also that there is pending litigation in the High Court about the interpretation of the rules, the interpretation of the process that is followed, there is also, I believe, a challenge on the constitutionality of the process followed in this hearing, and also, I believe, a constitutional challenge on the rules. That is best left for the Western Cape High Court to deal with. It is not fair nor appropriate to expect Mr. Counsel now to give legal opinions on the interpretation of issues, which is exactly now pending before the High Court. And I ask my learned friend to please tailor his cross-examination questions appropriately.
Thank you, Advocate Golden. Advocate Kasiboto, that's the request. Please refrain from the legal principles and let's come to the level of this hearing.
Well, Chairperson, I was hoping that you are consistent on that, because when I raised objections to the line of questioning of the initiator, you allowed an opportunity to respond before you ruled. I was hopeful that you'd grant me the same indulgence.
You can still have your time. What will
Thank
you
you,
respond be?
Thank you, Chairperson. I object to the objection for this reason. The first one is that Mr. Baso is not a layperson. He is here to advise on the rules. That is what he does. He advises Parliament on the rules. The second point is that he himself in examination in chief gave reference to rules and what they mean, and I did not object to that. He would say the speaker exercised this rule, this is how the rule applies, and that is why the speaker came to this conclusion. There was no objection in that respect. It therefore be inconsistent of you, Chairperson, to stop me from that line of questioning. But I will respect your ruling nonetheless with this caveat. To the extent you stop me from asking those questions, then all the evidence that Mr. Baso gave on the rules must be expunged from the record and as evidence to the charges, because you can't have it both ways, where in respect of his own evidence, he can give interpretations of the rules. When it comes to cross-examination, I'm stopped from asking those questions. I'm going to therefore ask for your ruling in that respect, Chairperson.
Advocate Golden, is this how it has to be? Like the advocate here is indicating that during the evidence leading, the same legal jargon was used, for lack of better word, and now she's asking the same in line with how you conducted your evidence. I have recognized you. I see your hand, Honorable Kawa. Let me allow Advocate Golden first.
Thank you, Chair. Chair, as far as I recall, Mr. Kasiboto did not at all object to my line of questioning when it came to the rules of the National Assembly and in relation to the charges. So those are the charges that we are dealing with, and those are the rules. Also, you will recall that the charges were explained in relation to the members' conduct. What we see now is that Mr. Kasiboto is now wanting to choose legal argument questions to put that in cross-examination when it is more appropriate for legal argument and in written submissions at the conclusion of the factual evidence. So I stand by my objection and I leave any ruling, if appropriate, in the committee's hands.
Thank you, Advocate Golden. Honorable Kawa.
Thank you, Chair. And maybe let me confirm we are listening carefully to the proceedings as it takes place. Just to caution, Chair, through your ruling, that the concluding remarks that either has to come to the initiator or the lawyer, that will be done at the end. I am concerned us having to listen to instructive request to say the evidence be expunged, because that could be a determination of a request recommendations to the committee at a later stage. Remember, Mr. Kaso having to be here giving evidence. It's not only for the learned friend, the representative of those alleged, not even guilty, alleged to be, and it's not only for the initiator. We are listening to both sides of the story. We can't be conclusive to be instructive. I'm just calling for the chairperson to just give direction to that. Thank you, Chair. We are still listening. Thank you.
Thank you, Honorable Klava. Advocate Kasibot. Indeed, your objections were on the initiators leading questions. You have objected on numerous occasions to say she is leading the witness. Can I request you that you leave the legal arguments for closing arguments by both teams at the end of this, so that we proceed with the cross-examination without putting on the legal arguments?
Thank you, Chairperson. I abide the ruling, but I just need guidance then as to what I'm permitted to do. You would have heard the initiator say, she asked questions around the rules and I did not object. And that is true because it is permissible. All I'm simply doing, it is the same exercise. For example, I am now dealing with Rule 73, which Mr. Kaso led evidence on. He read Rule 73. I am now simply asking him questions about that evidence on Rule 73. I have made no legal submission either than to test what is in chief. The initiator has told you that she asked him questions on the rules. I am simply doing the same thing. So at the risk of disregarding ruling, Chair, I'm just seeking guidance on what it is exactly you're asking me to do. Because all I'm doing is asking questions on the same Rule 73 that I allowed questions on when the initiator was examining Mr. Kaso. So I'm just asking for your guidance, Chairperson. I'm doing nothing that the initiator did not do.
What I'm asking on Advocate Kasiboto is for you to confirm the instances he responded to as a witness on the rules, not making legal arguments. As I'm saying, let the arguments be, the legal arguments, be reserved for both teams, and the closing arguments that will be, both of you will be afforded a chance to do. There's a way of going around asking with the rules, instead of making it a legal argument. So please, let's deal with this in a way that is in accordance with what we are supposed to do here. Advocate Golden is saying what you're doing as we ask questions on the rules, you're making legal arguments. So I'm saying refrain from doing that so that we are able to proceed with the level of the hearing, not legal arguments as he says. But that is not for this platform now.
What point of order, Chair? Can I raise on a point of order?
Honorable Tambo.
Yeah, but can the initiator
Sorry, Madam
illustrate? No,
Sorry,
it's
Madam
wrong. It's wrong. You are limiting our counsel from how it must cross-examine. There was no legal argument that was raised here.
Sorry, Madam Chair.
EFF is saying that they're doing exactly what the initiator had done.
Yes,
They're
Honorable Tambo, just hold on.
The
Just
rules
hold on. There's the point of order here.
Earlier on.
There's a
Why
point of order, Honorable Tambo. Just hold on.
You're discriminating our
Just
counsel.
hold on. There's a point of order. Just hold
No,
on.
but on my order, it's my point of order. Who's raising an order on top of mine? You're discriminating our counsel. Our counsel is doing the exact same thing the initiator did. They're referring PASO to the rules. PASO explains the rules to the initiator. Our counsel is doing the exact same thing. You're framing that as legal argument.
I have strong object at this stage. Madam Chair, sorry, strong object. If you could allow me to speak.
Wrong.
Honorable Tambo, just hold on.
Why do you want to speak when I'm speaking? What type of behavior is that? I'm saying to you, I'm raising on a point of order. You are speaking while I'm speaking. Our counsel wants to do the exact same thing the initiator did, getting counsel to clarify on the rules. Why is it being framed as legal argument? But when the initiator did it, it was not discriminated against. You're discriminating against us here, and that's why we said this is a farce. Allow our counsel to ask for clarification on the same rules that counsel clarified for the initiator. Why are you discriminating against our counsel, making illogical rulings like this? It's wrong. It's wrong.
Advocate Golden, can you come in? I will come back to Honorable Tambo.
Thank you, Chair. Chair, the nature of my objection is really a simple and it's a procedural one. The members of the EFF are represented in this hearing by legal counsel and an instructing attorney. They are not allowed to interject in any of the proceedings. They must do so through their legal team. That is the proper way of conducting this hearing. And I ask that you please prevent that from happening again. Otherwise, I will ask that the relevant member be muted. Thank you.
Thank you, Advocate Golden. I will not do that again. I will not give the affected members. Like it is indicated, Honorable Tambo, may you please raise your objections through your legal team so that we avoid these situations. Advocate Kasiboto, can we continue?
Well, then, Chairperson, I take issue with that as well. Before we got here, Mlenzane MP, Taba MP raised objections in this house about my conduct and my line of questioning in the comments I was making. You did not make a ruling that they must do so through their legal representative. Why is it then when my member, a charged member, who's obviously concerned about this process and is concerned about his rights and his interests, raises objections as well to protect his interest, why then is he being asked to speak through me? What is the distinguishing factor between the objections raised by the ANC MPs to the objection is just raised?
Yeah, I'm a
Before
member.
I go to,
To that.
before I go to Honorable
I'm a
Tambo,
member of parliament here. I'm a member of
before I
parliament.
go to Honorable Tambo, I'm still speaking here. Before I go to Honorable Taba, Advocate Kasiboto, if you could just say members of committee, refrain from calling them members of the ANC in this platform. They are here representing a committee of parliament. So it will not be okay that you say members of the ANC. We are a multi-party committee that constitutes this committee that is here. Sate Club, your hand is raised.
Thank you, Chair. In line with your advice and guidance, Chair, we don't want to say, Advocate, perhaps you may have wanted to check their credentials. I'm participating in the meeting with the Chair as a member of the committee, not charged or what. Even Honorable Mlenzane is a member of committee. Even Honorable Ndlozi is the member of committee. And we also have DA members as members of the committee. We are not partisan. Thanks, Chair.
Thank you, Honorable Taba. Advocate Kasiboto, we're going to continue.
Chairperson.
The members of the committee, as and when they raise hands, I will recognize them. They are members of the committee and members that you are representing. They will have to speak through you so that your cross-examination is seamless. Can we then continue?
Thank you, Chairperson, for your ruling. Mr. Kaso, before the engagements, I've taken you to Rule 73 sub 1. Are you still there?
Chairperson, yes, I'm still there.
I'll read that rule again. Excuse me. It provides that if a member refuses to leave the chamber when ordered to do so by the presiding officer in terms of Rule 70 or 71, the presiding officer must instruct the sergeant at arms to remove the member from the chamber. and the precincts of Parliament forthwith. And I placed emphasis on the word must before. Now, the question I want to ask you is this. When the Speaker wants to remove someone from the chamber, she must, as a starting point, call the sergeant at arms, not so.
When a member refuses to leave the chamber. the Speaker
Yes.
calls the sergeant at arms. Yes.
Yes. And that would precede her right to call the Parliamentary Protection Services, not so.
It is, it precedes that right at that starting point, but it's important, Chair, that you also, okay, maybe let me not say this, I might have to say it later on. Let me hear you out, Mr. Swoto. My apologies for that.
Thank you. And before she can call the sergeant at arms, she must first ask the member to desist from the impugned conduct, not so.
No, it's not always the case. But let's read Rule 70 so that you can understand my point.
Sure.
Rule 70 says, if the presiding officer is of the opinion that a member is deliberately contravening a provision of these rules, or that a member is disregarding the authority of the chair, or that a member's conduct is grossly disorderly, he or she may order the member to leave the chamber immediately. So there's no asking the member to desist from what the member is doing.
But you can accept that her practice was to ask members to desist from doing what she alleges to be contravention of the rules, not so.
Her option at points was to ask members to desist, but there is no requirement for her to do that in terms of the rules.
And if she fails to call the sergeant at arms and immediately instructs the Parliamentary Protection Services to remove a member, then she's not acting in accordance with Rule 73, not so.
Chairperson, that's the point I wanted to get to earlier, and I will get to it now. If you read Rule 73(6), sorry. Any member or members who contravene sub-rule 5 may, on the instruction of the presiding officer, also be removed from the chamber in the presence of Parliament. Rule 5, no member may in any manner whatsoever physically intervene in, prevent, obstruct, or hinder the removal of the member from the chamber in terms of these rules. Any member, then 5 follows. Now, there is no suggestion in these 2 rules that sergeant at arms must be called first. That is why when members are physically intervening in the removal of members, the Speaker would call the protection services. So that is my response to your question.
I apologize, that answer was long and I'm not too sure what the answer is. So having said what you said, if you can then sum up that answer perhaps in a sentence, because I want to understand you properly. I am putting it to you that the Speaker may not call Parliamentary Protection Services prior to invoking the services of the sergeant at arms when removing a member from the chamber.
Chairperson, my response is Mr. Kasiboto is incorrect. There would be instances where the Speaker asks the members to be removed immediately from the chamber without having to call the sergeant at arms.
Removed by whom?
By the protection services.
Please refer me to that provision.
Well, the rules are clear that you have the sergeant at arms, you have protection services, and the members may be removed by the protection services at any point. So there's no requirement that in every instance, the Speaker has to call the sergeant at arms, even when the situation calls for her not to call the sergeant at arms.
I'm really struggling to follow. I've read Rule 73(1). It specifically says, when the Speaker wants to remove a member who refuses to leave the house, she must call the sergeant at arms. In other words, not sergeant at arms or the protection services. She must call the sergeant at arms. You are saying I'm wrong. I'm now asking you what rule empowers her as a starting point to call the parliamentary protection services.
Chairperson, I think it's important to understand the sequence of things here. Rule 73 must be read in line with the Rule 70. Here, a member is being asked to leave the chamber. Yeah, member being asked to leave the chamber. A member refuses to leave the chamber. Then the rule says the sergeant at arms must be instructed to remove the member. Now, in Rule 70, a member has, 7.5 and 7.6. A member has already been asked to leave the chamber, and these other members, in defiance of what the speaker has said, then physically intervene. Now, the rule says those members must also be removed from the chamber and the precincts forthwith. And the application of this rule has always been that at that point, there's no calling of the sergeant at arms. Those members are removed from the chamber by the protection services. That is my response. I hope Mr. Kasiboto now understands my point. He may disagree with it, but that is where things are.
I do not understand your point, Mr. Glasso, so I'll just put the proposition to you and then we can engage on that basis. The speaker must call the sergeant at arms when a member refuses to leave. And if the member refuses, only then can the speaker ask for the parliamentary protection services. Now, assume I'm correct. Answer as a matter of hypotheticals. In other words, now you're assuming I'm correct. I'm not saying it's your answer, but let's work with an understanding that I'm correct. It would therefore, if I'm correct, be improper of a member to be removed by the PPS as a starting point. Not so.
No. Mr. Kasiboto and honorable members, I think I've made this point that there are two scenarios here. There's a scenario of a member who has done something that the speaker views as unparliamentary. A member refuses to withdraw a remark. The member is asked to leave. The sequence is that if the member refuses, then you must call the sergeant at arms. And then the member is then assisted. If the member still refuses, then you call in the protection services. Now, the other scenario is these other members, in the course of the ruling of the speaker being applied, they intervene. Now, there's no provision here that then call the sergeant at arms or what, the application of this rule, and this is what we're talking about. The application of this rule is that the speaker would then get those members removed immediately from the chamber, forthwith. And that has always been the application of these rules, by the way.
This is the difficulty, Mr. Glass. You are now giving me your interpretation of the rules and how you see them. And I'm not taking anything away from that. I hear you. I am now saying, assume a position you are wrong and I am right, because I will submit to this committee later on that your interpretation is wrong and mine is correct. And if you then answer my question on the basis of I am correct, then it assists the committee make the determination. So forget what your interpretation is, and I accept it to be that. I'm saying now assume what I am putting to you, because I've asked you for a reference to a rule that says what you say, you have not done so. Now assume I am correct, that you cannot kick a member out as a starting point using parliamentary protection services. Assume that to be correct and answer on the basis of me being correct, not your interpretation of the rule. If I am correct, then the speaker would have been acting unlawfully by instructing parliamentary protection services without warning the member, without invoking the services of a sergeant at arms. Not so.
Chairperson.
Sorry, Chair. May I again raise?
Advocate Gordon.
Sorry, Chair, and I must just
Yes.
say up that I do not want to unnecessarily, and nor can I, unnecessarily restrict opposing counsel's cross-examination. However, I think that we have now, or he has now gone beyond that which is fair and that which is permissible. He has now repeatedly put the same issue to Mr. Kaso. Mr. Kaso has answered on no less than 2, maybe even 3 occasions. His answer hasn't changed. It doesn't matter how many times Ms. Kasiboto asks the same question. He's not going to get a different answer. He's badgering Mr. Kaso into giving him an answer that he wants, which he is not getting. Chair, I ask that you instruct Mr. Kasiboto to move on and to keep whatever interpretation, legal arguments he has to make for the appropriate time when we deal with legal argument. Thank you.
Thanks, Advocate Golden. Advocate Kasiboto.
Thank you, Chairperson. Unfortunately, Mr. Kaso did not answer the question I was asking. And my understanding was he's not answering it, not because he's evading my question, but perhaps he doesn't understand my question. So the only reason I repeated the question was so he understands what I'm asking of him. If he refuses to answer the question, well, then so be it, I'll accept that. And perhaps I could assist the chair and make your task easier and accept that I will move on and not ask that question again. But I just want to place on the record this. Assuming I am right about my interpretation, assuming that the speaker cannot use the PPS as a starting point, then it must be that when she does that, she's acting unlawfully. That's the point I was getting at. And I'll then ask the second question. And the second question is this, Mr. Kaso. With your leave, of course, Chair, I'm not disregarding the fact that you're supposed to make a ruling. I just feel I accept and I'll move on. And if you're happy with that, Chair, then I'll just proceed.
As you move on, please ask your questions, not too many times repeating, because we are all here. He's been responding. Just try to move on. If the response is not what you expect or it's not satisfactory, just know that and move on to the next question. It will help us all. We can proceed.
Thank you, Chairperson. Mr. Kaso, let's go to Rule 73, sub 11.
Yes, I'm there, Chairperson.
That rule says, in the event of violence, so there's a qualification as to when this can happen. In the event of violence ensuing in the chamber as a result of members resisting removal, the presiding officer may suspend proceedings and members of the security services may be called upon by the speaker during such period of suspended proceedings to assist the removal of members from the chamber and the precincts of Parliament forthwith in terms of Section 4.1 of the Powers and Privileges Act, provided that the security services may intervene directly anywhere in the precincts and the chamber in terms of Section 4.2 of the Act when there is immediate danger to the life or safety of any person or damage to any property. The point I want to make is it is there clear when the parliamentary services may be invoked. You have suggested, no, there are other instances where their powers may be invoked. And I'm asking you to direct me in the same way as I've directed you to your version of things.
Chairperson, I think it's necessary at this point, and I hope I understood Mr. Kasiboto. to just explain what this rule, sub-rule 11 is about. And to
Mr. Glasso, sorry to do this to you. And this is how then I get into trouble, because you answer questions I'm not asking you and I'm forced you to ask the question again. I'm not asking for your interpretation of sub 11. I am asking you to direct me in the rules where it says parliamentary services may be invoked on the version that you have given, not interpret what I've just read to you. That is my question to you.
maybe I should first seek clarification, Chair. Can you just clarify your question again, Mr. Kasiboto? Why are you reading Rule 11?
Mr. Glasso, I ask you questions, not the other way around.
Chairperson,
I'm sorry, Madam Chair. That is grossly unfair to the witness. If a witness seeks to clarify a question, he must be permitted to do that, because if he doesn't do that, he may be misled.
Advocate Kasiboto.
There's no such a thing, Chairperson. If I'm asking examination, cross-examination questions, I want to discredit the version of the witness. How then must he have a benefit of what I'm trying to achieve? I mean, it's just, with respect, Chairperson, I object to the objection. I am entitled to ask a question without telling the witness what the point of my question is, because what I'm trying to do is to discredit this version. I can't then assist him dodge my question by understanding why I asked the question, Chairperson, with respect.
Chairperson, with your permission, I may?
Yes.
Chairperson, the reason I wanted clarity, because I thought I might have misunderstood him, because I want to indicate, and this is where hopefully he's going to clarify this, because I'm not certain whether by reading security services, he is talking about parliamentary protection services. That's the clarity I wanted.
I'm happy to move on, Mr. Glasso. I've made my point. And just for future purposes, you cannot ask me why I'm asking you a question. You can ask me, what does my question mean? Or ask me to clarify the question. What you're not entitled to do is ask me why I'm asking you. And the point is simply this, Mr. Glasso. Mr. Tambo MP, who's one of the charged members, stands up when the parliamentary protection, before we get there, the speaker invokes the services of the sergeant at arms, asking him to direct and ask Ms. Chirwa MP to leave the chamber. And if you object to the account I'm giving you, I'm happy for us to watch the video. The sergeant at arms proceeds towards Ms. Chirwa, presumably to effect the instruction of the speaker. Do you recall that engagement? You testified about it earlier.
Even that I have forgotten things, I'll ask for the tape to be prepared. Yeah.
I'm happy. What then happens as the sergeant at arms approaches Chirwa MP, Mr. Tambo stands up and a question is put to you. What is Mr. Tambo doing? I wrote it down. Your answer is Mr. Tambo is talking to the sergeant at arms. Do you remember that?
Yeah, I do.
You've given your answer that the sergeant at arms is talking to Mr. Tambo. You then change your version. Do you recall when you changed your version?
I don't recall changing version, Chair, but Mr. Katsuboda can remind me about the change of version.
There was a question, presumably because the answer you've given is not the answer you're supposed to give. And the question is led by, no, but Mr. Tambo is standing in between Miss Chirwa and the sergeant at arms, what is he doing? Do you remember that question
No,
from the initiator?
I do, and there was no change of version there.
And then what happened is you gave an answer. You said, oh yes, he is blocking the sergeant at arms. Do you remember that?
Chair, what I would have said, and I'm happy to replay that. I would have said Mr. Tambo they were talking, and the sergeant at arms was sent to assist the member to leave the chamber, and he was blocking the member from doing that. The staff member from doing that.
You've basically said what I've just said. But what you are not doing is accepting. You've accepted earlier. You can change your version again now. I'm happy for you to do that. But all I'm simply saying to you is you accepted that your first answer was Mr. Tambo is talking to the sergeant at arms. And that's where you stopped. The initiator came in and gave you her perception of what is happening, which is no, but Mr. Tambo is standing between Ms. Chiro and the sergeant at arms. You then gave a version which now says he is blocking the sergeant at arms. And I'm saying to you, that is the evidence, and I'm going to make submissions in that respect. I then again say, your version of Mr. Tambo blocking sergeant at arms was prompted by the follow-up question, which then led to you changing your version from he is talking to the sergeant at arms to he is blocking the sergeant at arms. Do you have a comment to that?
Chair, yes, I do have a comment. I don't understand the blocking of, the change of version. The effect of what Mr. Tambo was doing was blocking the sergeant at arms, and that's what it is. It was just continuation of the response. If I happen to stop before I got to that point, and that is understood as change of version, then that is for Mr. Kasiboto, not for me.
Do you know what Mr. Tambo said to the sergeant at arms?
I don't know what he said.
Did you ask the sergeant at arms what Mr. Tambo said to him?
No, I did not ask him, and there was no need for me to ask him.
Surely, if you're going to charge a member for disorderly conduct, you care about the facts that surround that conduct, not so?
Chairperson, the answer is simple. If Mr. Tambo had an issue to raise with the ruling of the speaker, it was to raise a point of order and raise that point of order. It was not for Mr. Tambo to engage the sergeant at arms who had been directed in terms of the rules to go and remove a member. That's obstruction. That's what it is.
How do you know Mr. Tambo wanted to raise a point of order or challenge the ruling?
No, why raise it to the sergeant at arms through you, Chairperson? Sergeant at arms was not the presiding officer on the day. Speaker was the presiding officer.
Who said that is what he said to the sergeant at arms?
No, but that's what you're asking. You're asking me what if he wanted to raise a point of order? And I'm saying that even if he did want to do that, Sergeant at arms was not the right person to do that too. And Honorable Tambo, as a member, knows that. Speaker is the chair.
I said no such a thing, Mr. Glasso. I said to you, do you know what Mr. Tambo said to the sergeant at arms? You said no.
Yes.
I then said to you, surely you care about the facts that surround kicking out of members. I said no such a thing about a point of order. You came up with a point of order. Now I'm asking you, how do you know that engagement was about a point of order?
No, I don't know. I indicated earlier on that I don't know what the issue was.
Yes, so I did not speak about a point of order. You did.
Okay.
Because you're assuming where I'm going, isn't it?
No, look, I'm not assuming. I'll be happy to know where you're going, but I'll wait for you to ask the questions.
Very well. And I put it to you that for someone who's responsible for the procedures of Parliament and someone who advises various structures about these proceedings that we are sitting in now, surely you must care about facts that surround impugned conduct, not so?
Chairperson, I'm trying to be as helpful to this process as is possible. I care about what goes on, but it was not my duty to ask the Sergeant at Arms what Mr. Tambo was saying to her. As it would not have been my duty to ask even the production services when the members were exchanging words with them, or at least talking to them, what they were saying to them. So, yeah.
Do you know if anyone asked Mr. Tambo or the Sergeant at Arms as to what the engagement was about?
No, I don't. I mean, if there's an interest to ask the Sergeant at Arms, he's a staff member, he can be called and be asked what he said.
And to the best of your knowledge, no one has ever asked the Sergeant at Arms and Mr. Tambo what the interaction was about.
No, I don't. I don't.
Yes. Yet, all these structures that were involved in bringing these charges make it definitive, or at least at a prima facie conclusion, that Mr. Tambo stood simply to block the Sergeant at Arms from performing his tasks. Not so.
That is a charge, Chair, and of course, it would be for Mr. Tambo to state his version in this forum.
In hindsight, with your involvement, the Physical Removals Committee, the Rules Committee, the Parliamentary Committee that is seized with this matter, in hindsight, do you think it would have been proper to have the version of the Sergeant at Arms and that of Mr. Tambo before a determination is made that he's simply obstructing?
Chairperson, I believe that the committees that dealt with these matters sorry, I don't know. I believe that the structures that dealt with these matters, they did a proper job, and I really did not see a basis for Mr. Malimi, sorry, to be asked what conversations he had with members. And in the event that Mr. Malimi thought it was necessary to report to the speaker, like when he wanted to, when he was sent to remove Miss Honorable Mare, who complained about the handling of members by production services. Mr. Malimi did report that to the speaker, and the speaker made certain remarks about it. So if he thought it was necessary to report the matter, he would have reported it.
I'm asking you the question whether in hindsight there should have been some sort of discussion, because I imagine before these charges are proffered against my members, there's some sort of investigation, fact-finding, reviewing of the Hansard, reviewing of the video material. It just makes sense to me, at least I would suggest to any rational person, that if you've got two people engaging and you called it, they were talking, or rather Mr. Tambo was talking to the Sergeant at Arms, and then are prompted to give a different answer by a follow-up question, surely in the course of that investigation, it is only proper, particularly if your answer is he was talking to ask as to what it is that we're discussing before you make a determination as to whether it was blocking or not.
Chairperson, I mean, I don't agree with that version. I believe that the way the matter was handled is proper, and I believe that this forum where we are now, Honorable Tambo, if he thinks what he discussed with the Sergeant at Arms is worth presenting to this committee, I'm sure he will do that when he gets to that point. So I believe that the structures that have dealt with this matter dealt with it properly.
And I'm asking this line of question because then eventually what you see before the Sergeant at Arms even reports to the speaker directs that Mr. Tambo be evicted by the Parliamentary Protection Services. Is that of concern to you as someone who's the custodian of the procedure in terms of the rules?
No, it is not of concern, because no member is allowed to hinder the execution of the functions of the Sergeant at Arms when the Sergeant at Arms is, or the protection services are sent to assist a member to be removed. As I want to put the point I put earlier. The chair, the house is run by the chair of the house. So if a member has any concern that the member believes should be raised with the speaker, then they must raise a point and say that to the speaker. So that's my response.
And just to round off this line of questioning, you can accept first that the speaker at no point asked Mr. Tambo to desist from doing what he's doing, correct?
I don't recall that. And she was not required because members know, at least I expected to know the rules, what the rules say.
Well, if she's not required to tell members to stop what they are doing, then why does she do it?
No, I'm saying, Chair, that there is no requirement for her to say, Honorable Tambo, make way, because the member is supposed to know that he's supposed to make way. So if she had chosen to do that, she would have chosen to do that. But there is no obligation on her to say that.
You can also accept that at no point did the speaker ask Mr. Tambo to leave the house. Not so.
Because the rules say the member must be removed in the chamber.
You can also accept at no point did the speaker ask the Sergeant at Arms to escort Mr. Tambo out of the building. Not so.
Yes, because there's no such requirement.
And the only thing that happened after Mr. Tambo stood and spoke to the Sergeant at Arms is that the same protection services that were brought in were then asked to also usher out Mr. Tambo as a starting point. Can you accept that?
That is correct. And that's what always happens when members block the removal of members, of other members.
Very well. Before I move to the next subject matter, let us round off Ms. Mkonto's evidence. I'm taking you back to where we started. We have dealt with the question of charge 3. So charge 3 dealt with, the charge says, and it's on page 69. It is alleged that you are guilty of conduct constituting contempt of parliament in terms of section 13C and 13DI of the powers, privileges, and immunities of Parliament and Provincial Legislatures Act, and that as a member of Parliament and during the sitting of the National Assembly on 10 June 2022, when the President responded to his budget vote speech, that you contravened section 7A of the Act, in that you willfully refused or failed to obey Rule 73(1) when you refused to leave the chamber when ordered to do so by the presiding officer in terms of Rule 70 and or 71. You continued to refuse to leave the chamber when the Sergeant at Arms requested you to leave. The presiding officer then instructed the Parliamentary Protection Services to remove you from the chamber. And then it concludes by saying your conduct improperly interfered with the exercise or performance of the House of its authority and functions. And I've suggested to you that she's not guilty of this charge because it was physically impossible to have committed this charge by virtue of her being absent. Let's now deal with charge 1.
Sorry, Madam Chair, if I could just, and also just for purposes of the witness, is it the version of Ms. Konto that she was not present in the National Assembly at all that day?
Chairperson, the version of Ms. Mkonto is that she cannot have been guilty of charge 3, in that it was physically impossible for her to be present, or rather to commit the charge by virtue of her not being physically present in the chamber.
Sorry, Chair, I need clarity on this because this is the version of Ms. Mkhonto. The witness also needs the proper version of Ms. Mkhonto. Is it her version that she was not at all present in the National Assembly on the 10th of June 2022? It's a yes or a no answer. And I ask my learned friend to please give us, the witness and the committee, the proper version.
Advocate.
Chairperson, my client carries no burden. The burden when a charge is brought is for the initiator to prove. In fact, she was at pains earlier on to make the point that she stands and falls by what she leads before this house. My client's function is to merely discredit and not to assist the initiator. The difficulty with answering the question of the initiator is that then it exposes and gives a clue to Mr. Counsel about what I'm going to ask him now. The prejudice is if I answer that question, then I can't make the point that I want to make now. And for those two reasons, Chairperson, I refuse to answer the question.
Thanks, Advocate Kasiboto. We then move. You're refusing to respond to that question. We note in that as it exposes your next questioning.
Thank you, Chairperson. And
Sorry.
if
Madam
Oh.
Chair, if I may respond.
Yeah, you still want to come in?
Thank you, Madam Chair. Madam Chair, I'm quite flabbergasted by my learned friend's answer. This is a very basic principle of a hearing of this nature. And in order to be fair to the witness, but also so that we can prepare for cross-examination of Ms. Mkhonto, we need to know what her version is, what her full version is, and it's got nothing to do with the burden or with my onus that I must discharge. This is a factual issue. It is either a fact that Ms. Mkhonto was in the National Assembly and attended the proceedings on the 10th of June, or she was not at all there, she did not attend. So this is a factual issue. This has got nothing to do with the onus. And this has also got nothing to do with respect to Mr. Kasiboto about his style of cross-examination and questions that he may want to ask as a follow-up. As a matter of fairness to the witness and to the entire process, because the fairness issue is not just a fairness issue to the members that is charged, Madam Chair. It's also a fairness issue to the initiator and to the case that I must present. So I ask again that the full version, the factual version of Ms. Mkhonto is put to Mr. Counsel for his comment, and so also that we can prepare properly. We have a right to that information, to what her version is. Thank you.
Chairperson, before your ruling, if I can respond to this new submission, if I could indulge and respond to that one specifically as well.
Okay. Please respond.
Thank you, Chairperson. I want to make 4 brief points. The first is this: it is rather surprising that charges are brought against a member, yet we are asked to tell them what happened, who was where. It's their version that she was in the chamber. That's their version. How are we then asked to correct their version and assist them in ascertaining the truth? My client has no onus or burden to assist the initiator. The second point is this: where is the register? If this process was taken seriously in terms of investigation, and I say that with respect, and perhaps I'm better advised to use a different word. The point I simply seek to make is, if you want to ascertain the attendance of members at a chamber or not, there's a register for that. Why can't the initiator have recourse to that register? The third point I want to make is this. The claim that we must give a version is so that we can help the initiator prepare for cross-examination. Well, with respect, I was not told what Mr. Castle's version will be. I heard his version for the same time in this house, and I prepared my cross-examination as he was testifying. Why should the initiator enjoy a special benefit? And I'm saying to this house, we may well call Ms. Mkondo, and then at that point, she can prepare for a cross-examination. She may decide not to give a version at all. The rules say she's entitled not to give a version at all. She's got that right. And if she then chooses to exercise that right not to testify, then how are we compelled to give her version? And I'm saying in light of that, Chairperson, I refuse to answer the question.
Thanks, Advocate Kasiboto. That is noted. I hope Advocate Golden has also noted that refusal. May we proceed?
Thank you, Chairperson. I was taking you through charge 1 of Ms. Mkondo, which you spoke about earlier. It says, it is alleged that you are guilty of conduct constituting contempt of Parliament in terms of Section 13C and or 13DI of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act, in that as a Member of Parliament and during the sitting of the National Assembly convened on 10 June 2022, when the President, Mr. Cyril Ramaphosa, responded to his budget vote speech, you contravened Section 7A of the Act when during the proceedings you willfully refused and or failed to obey Rule 69C, when you repeatedly undermined the authority of the presiding officer and or repeatedly refused to obey the rulings of the presiding officer and or disrespected and interrupted the presiding officer while the latter addressed the House. Your conduct disrupted the proceedings of the National Assembly and improperly interfered with the performance by the House of its authority and functions. How did she do that, Mr. Glass?
Chairperson and the committee, the point was made earlier by Mr. Kasiboto that the member was not in the House. And I did say to this committee that it's possible a mistaken identity on my part, genuine mistaken identity on my part. And therefore, if the member was, and I've accepted that version, if the member was not in the House, then I am not able to say how she did this or did not do this, because the version is that the member would not have done it in the House. And I've explained the issue of the identity of members to the best I could. Thank you, Chairperson.
Would the same apply to charge 2?
Certainly, Chairperson, that would apply to the charges, these 2 charges.
Would the same apply to charge 4?
Chairperson, that would apply as far as I'm concerned, on my part at least, as a witness.
We've already dealt with charge 3, you remember?
I do.
So that being the case, we now accept she can't have been guilty of any of these charges.
Chairperson, that will be for the committee to deal with that. I'm just giving my version as a witness appearing before this committee.
I think that's fair. Let us deal with the, if you can just give me a second. Testified extensively. You've testified extensively about members of Parliament that called the president a criminal and a money launderer. Do you remember that?
I remember answering questions around that, yes.
And your answer with reference to the rules said that was a breach of the rule in that it cast aspersions on the president. Do you remember that?
Yes, I do remember that, and I said more than that, yeah, on the issue.
And on the basis of that, then the speaker is entitled to ask for the removal of those members. Do you remember that?
The speaker is entitled to ask for the withdrawal of those issues. And if there's disregard for authority to ask members to leave.
Yes. And one would imagine that if another member equally casts an aspersion on another member, the same treatment must be meted out by the speaker towards the same or towards that particular member who's conducting themselves likewise. Would you accept that?
If the speaker would have heard that, then maybe if a point of order was raised, or there had been an initial ruling by the speaker on the same issue, the speaker would do that, yes.
I presume yet again, in fact, you've given testimony that you would have gone through the Hansard, you'd have gone through the video that you are dealing with. Can you just confirm that again?
Yes, I've gone through the video and the answer, and specifically in respect of the members that are charged.
Correct. Let's have regard to page 263,
263,
267, my apologies.
267.
Yes, sir.
Yes, I'm the chairperson.
If you have regard to the caption of what Ms. P.P. Makubele had said, she says, Floyd, your name is also mentioned in the matter of Gadi's child. Why are you speaking here in Parliament? And this was a comment made after the Deputy President of the EFF, Shibambu MP, had said the incumbent president has no standing in that house because he's a criminal and money launderer.
Yes.
As the custodian of the rules, and bearing in mind the attitude of the speaker to people casting aspersions, what should the speaker have done about the conduct of this member?
Well, if a point of order was raised, or if the speaker had heard the member, she may have said that she would look at the Hansard and rule on the matter. I don't know what she would have said or what she would have done.
I assume you would have read this page in preparation for this, wouldn't you have?
Yeah, I've read the page.
Did you say anything about this to anyone?
No, I did not. I did not need to say anything about it.
You can accept then that this member of parliament cast aspersions on Shibambu MP and there was no consequence for that conduct, not so?
And there was no point of order raised either. Yeah.
If you then have regard to page 284,
Page 284. I
Yep.
am there, Chairperson.
if you go to the middle of that page, you see there Ms. C.M. Piri. She says, Vendor Building Society, VBS, Shibambu heist. Do you see that?
Yeah, I see that.
And what she's suggesting there is Shibambu MP is part of what the report of the VBS report She is implying that he's part of what is contained in that report and is being implicated as being guilty in what she calls the VPS Shibambu heist. Can you accept that?
That may have
Sorry,
been
if you could just give me the page number, please.
284. Your answer, Mr. Counsel?
that may have been the intention of the member. Yeah.
Do you know if Ms. Piri was charged for saying this?
No. No, and I don't know why she would have been charged for saying it. But what
Do you know-
what could have happened if there was a point of order? She could have been asked to withdraw, but charging is an extreme step.
Do you know if the speaker reprimanded her for this conduct?
No, there was no reprimand, but there was no point of order, and I don't even know if speaker heard her say this.
So you've got a shield to raise disparaging remarks if there's no point of order raised.
Chairperson, I think I do need to explain this in answer to Mr. Kasiboto. It is not a shield. It is an accepted parliamentary practice that rulings can be given either in reaction to a point of order or when the speaker hears the matter being said and believes that the matter is outrageous and has to be ruled on. So there's really no shield. And yeah.
Can I ask you this? Did you read this page in preparation?
Chairperson, I read the Hansard.
And I'll assume that all the members of all the subcommittees would have read the Hansard, they would have watched the videos. I'm assuming that in their favor, including the members of this committee. Do you know if any of them raised an issue with this?
No, I don't know, Chairperson. And of course, I think I should say this, that parliamentary practice indicates that points of order must be raised immediately in the House for the matters to be dealt with.
This is the difficulty. So if the speaker knows that there's conduct in breach of the rules, until someone raises a point of order, such a person won't be sanctioned.
Chair, I've said it's not always the case. It's not always the case, but it is, members are encouraged to raise points of order when they believe that something is out of order.
Should the speaker have sanctioned these two members for these comments?
If the matter was raised, the speaker would have considered it and the speaker would have made a decision. I wouldn't say what decision she would have made.
What would your advice have been to the speaker?
Of course, if the matter is I would have said to the speaker that members must raise substantive motions if they want to raise these issues in the House.
Maybe let me ask the question more directly. If the speaker asked you, or any of the committees you advise asked you, is this conduct by these two members parliamentary and are they sanctionable under the rules? What would your answer have been?
I would have said they are possible sanctionable. Of course, the speaker would take the final decision on the matter.
And we now know they've never been sanctioned.
Because the matter was not raised and the speaker might not have heard these members when they raise these issues.
Is there a provision for members to be punished, call it in hindsight, or outside of the parliamentary process?
Chairperson, I request Mr. Kasiboto, with your permission, to repeat the question.
Is there a procedure for members to be punished for unparliamentary conduct outside of the sitting of parliament?
All right. Mr. Kasiboto will can ask the question again if I did not understand him well. Parliament has processes in place, and it's going to be a prolonged answer because I'm trying to get to what he's saying. I don't want to ask him to repeat repeatedly. And so, firstly, I don't understand him when he talks about outside of the parliamentary sitting. I think that's what he said. What I can say is that matters coming out of the House, if there is a basis to refer them to structures such as the Ethics Committee or the Powers and Privileges Committee, that is done, like what we are dealing with today. And that's really my response, and I hope I got his question correctly.
Can you accept that a remark that someone is guilty of being part of a syndicate of what is referred to as a VBS heist is analogous or comparable to calling someone a money launderer? Can you accept that?
No, I can't accept that because I don't know if it is the same. It would be a reflection on the member. That one I can say. But the analogy that you are giving me, I'm unable to accept it because I really have not applied myself to it.
Just as a matter of law, Mr. Glasso, you are saying to me you've got conceptual difficulties accepting that when you call someone a money launderer, it is an equivalent or just as negative of casting of character as calling someone part of a syndicate. You're saying just as a matter of criminal law, you've got conceptual difficulties accepting that.
I mean, you've changed the question now. The way I understood you to say was that whether calling a person a heist, money heist, VBS heist, and calling a person a money launderer, those are the same. That's the point I was saying. To call a person a VBS heist is negative. It is something that will be reflecting on the member in the same way that you call a person a money launderer. That I accept.
Okay. And you have testified before that the speaker has got a duty to apply the rule fairly across the board, not so?
Yes, that is in terms of the rules.
And you can accept then as a matter of principle that conduct that is the same or comparable must meet the same consequence as a matter of principle, not so?
If speaker becomes aware of such conduct, as the member say that, or the matter is brought to the attention of the speaker would consider it and deal with it appropriately.
Yes. I'm happy with that answer. Let me ask you this now. There are a number of members that you testified about who were sanctioned for calling the president a criminal and a money launderer. Do you remember that?
We were asked to either to withdraw those remarks. Yes. Well,
And they were sanctioned for calling the president. They said that is casting aspersions on the president. They were sanctioned for
Yes.
it. Yes. Are you aware by any chance of a decision called Malema versus the National Council of Provinces?
a decision,
A judgment.
judgment. You may remind me what it was about?
I take it the answer is no.
No, just remind me the context. I mean, there are many cases that we deal with in Parliament.
What happened in Malema versus the National Council of Provinces, which is a decision of this provision, of this province rather, is that Malema MP referred to the ANC members as being guilty of massacring, rather murdering people in Marikana. Do you remember those facts?
I remember the case not against the NCOP, but against the chairperson of the NCOP. And I remember that it was about ANC government, not ANC members, ANC government that massacred the people in Marikana.
Sorry, Madam Chair, I also just wanted to correct that. It was against the ANC government. The member,
Was against who, sorry?
sorry, my apologies. It was not a member. Is that it, Victor?
Chairperson?
Yes, Advocate Kasiboto, are we listening to Advocate Golden? And as you, well, after you dealing with this one, let's get a 5 minutes comfort break. Proceed, Advocate Golden. Let's hear what your plan is.
Can you just give me 1 second, please?
While I'm giving a second, in that matter, you'll recall that Malema MP referred to the NC government as people guilty of murdering people in Marikana, not so?
Yes, I remember that case very well. It's something that was said in a joint sitting of the House, and the matter went to court, and the issue was about the ANC government having massacred people in Marikana, and the court did not have difficulties with the government being referred to have massacred people in Marikana, but the committee must be reminded that it was about the ANC government. Thank you.
Yes. Chair, the initiator had interjected, wanted to make a point. That opportunity was granted. She asked for a second. If I can then just give her that second now.
Sorry, I now wanted to listen to what he said, and if you could just give me the 1 second now without continuing, would that be okay? Madam Chair?
Yes, ma'am.
And we can proceed. Thank you, Madam Chair. I'm happy with the way that Mr. Counsel contextualized the case. Thank you.
All right, thanks. Advocate Kasiboto, can we get a 5 minutes comfort break?
Sorry, Chair, I did not hear the number of minutes. I'm happy to take the break. Just confirm the minute.